Power does what it wants. Power does what it wants. Power does what it wants.
You hear that, folks? There are two sets of laws. One for the police and one for the ordinary citizen.
Hey folks, what's going on? It's Rogue Nation here with you. Tonight we're going to be fair using a frauditor troll video that he did about DMA's conviction on the Social Security office. So he has this AI robot reading over the verdict here for DMA's case, and I want to go through it with you real quick because I just want to point out a couple of things here, what I thought the judge got wrong and why I'm pretty sure that hopefully it was raised during the trial and it'll be addressed in the appeal process. But let's go ahead and begin. I've already fast forwarded it to the facts part of the case, so that's where we'll start.
United States District Court for the District of Colorado, Civil Action, United States of America, Plaintiff, v. Christopher J. Cordova, Defendant. Verdict: Michael E. Hegarty, United States Magistrate Judge. This matter came before me for a bench trial on March 16, 2023. The information charged: 2 counts. 1. Failing to comply with official signs of a prohibitory, regulatory, and directory nature and with lawful direction of federal police officers and other authorized individuals under 41 CFR Section 102 to 74.385, and 2. Unlawfully photographing federal property under 41 CFR Section 102.74.420. Based on the following, I find Mr. Cordova guilty on both counts. Facts: the underlying facts of this case are not disputed. Mr. Cordova went to the offices of the United States Social Security Administration, SSA, at 8000 South Park Lane, Littleton, Colorado, SSA office on Tuesday, August 2, 2022. He used a video camera as he entered the building, being a self-described journalist. This was an ordinary business day, during normal work hours, and in the SSA office were SSA employees, persons seeking the SSA's assistance, contract, security officers, and Homeland Security uniformed officers. Virtually the entirety of Mr. Cordova's experience in the SSA office that day, and certainly anything of relevance, was recorded, and material portions were replayed during the trial. The SSA office is a freestanding building with the SSA as the sole tenant. As one enters the building from the outdoors through exterior glass doors, there is a rectangular space of perhaps several hundred square feet with no furnishings of any kind, with plate glass windows at the fore and aft, and frame construction on the right and left. The glass in this space had taped signs in several places stating that photography and videography were prohibited, citing federal law and SSA policy. The signs bore the SSA's official seal. There was also a sign posting the SSA offices hours as 9 a.m. to 4 p.m. As one walks through this first space, there is another set of glass doors. These interior doors lead to the office space in which SSA employees do business with the public. Immediately inside the office space on the left are chairs for waiting customers. The rest of the office space includes desks, tables,
Okay, so we're going to stop right there and go over just a couple of things here. It talks about the rectangular space of glass, right, when you enter the first doors. So we'll go over that, but notice that there's no furnishings in this first area. It's just an empty space in between the outside and the inside set of double doors. Nothing else in there, so that's important. It's also important to recognize that there's chairs for waiting customers inside that second set of doors. All right, so that's important. Also, the signs that they're talking about now, these are the signs that we see at all of them, right? They say no recording allowed per CFR 41, and then they give this CFR that leads you right back to the CFR that we use, which says photographs for news purposes may be taken in the lobby, right? So it's weird how they're doing this like roundabout circular type deal, right? They're saying, well, this statute, says that you're not allowed to record, and here's the statute. And some of the statute says that you can't record. Some of it says you need permission if you're an attendant agency, right? But for news purposes, it doesn't say that, right? So the sign is lying to me, because for news purposes, I can take photographs in the lobbies, in the corridors, in the foyers. Just like this judge said in DMA's case, he said that he was allowed to be in that entryway taking photographs all day long, right? So it's legit, right? The judge says it, even though he convicted DMA because he went through that second set of doors, which we'll get into. He said that first set of doors was under C, and DMA was able to be in there, right? Well, he will say it here coming up, but so C applies, right? So when you have a sign saying no photography or filming, but yet the statute you direct me to says I can, and then the judge here says I can in that area, I mean, it's pretty simple to realize, right? So they're not given lawful orders, when they tell you to stop filming in a place that you're able to film. Those aren't lawful orders, right? So, all right, let's go on.
Chairs, a check-in kiosk, and 5 stations, marked AE, with partial walls between each, at which customers approach and talk confidentially with SSA employees who are behind glass windows. On the day in question, Mr. Cordova entered the exterior glass doors and filmed inside the first space. He was there perhaps 3 hours. Although contract and uniformed law enforcement officers were with him much of the time, they did not impede his filming or monologue. Because there were large plate glass windows on either side of the space, Mr. Cordova was able to freely film what was occurring beyond the interior, second set of glass doors. He filmed persons going in and out of the office, persons sitting in the office, and persons being assisted by SSA employees, with virtually an unobstructed view of the entirety of the office area. At a defined moment during his visit, Mr. Cordova declared his intention to walk through the second set of doors into the office area and continue filming. The officers who were present informed him that was against SSA regulations and that he would be arrested if he proceeded. The posted signs informed him of the same prohibition, and he was shown a copy of the actual regulation. Mr. Cordova testified at trial that when he went to the SSA office, he already knew the regulation and its contents. Further, immediately inside the interior, second set of doors was an obtrusive sign on a stand stating, personal electronic devices, cell phones, cameras, may not be used to take photographs or to make video recordings. This sign also had the official SSA seal. Mr. Cordova indeed entered the SSA office area while filming and monologuing and was arrested at that time. These charges ensued. Legal authority. First, I begin with the proposition, although not raised by either party at trial, that the regulations in question purport to impose criminal penalties. United States v. Baldwin, 745 F.3d, 1027, 1031, 10th Circle 2014. These regulations jurisdictionally form the proper basis for a criminal charge. ID. Second, I should assume that the ordinary meaning of the regulations language expresses its purpose and enforce it according to its terms. See Hart v. Reliance Standard Life, Inc. Company, 560 U.S. 242, 251, 2010, internal quotation marks omitted. When called on to resolve A dispute over a laws, meaning this court normally seeks to afford the law's terms their ordinary meaning. Ms. Chavez v. Garland, 141 SCT 1474, 1480, 2021. Count 1. Count 1 alleges Mr. Cordova violated 41 CFR, Section 102 to 74.385. Under that section, persons in and on property must at all times comply with official signs of a prohibitory, regulatory, or directory nature and with the lawful direction of federal police officers and other authorized individuals. Based on my analysis of Count 2, see info Section 2, I find beyond a reasonable doubt the SSA law enforcement officers gave Mr. Cordova lawful direction, to not film in the SSA Interior Office and warned him that he would be arrested if he did, yet Mr. Cordova failed to comply. Mr. Cordova also failed to comply with official signs of a prohibitory, regulatory, and directory nature. Incidentally, unlike the language in the following regulation, under Count 2, Mr. Cordova does not challenge the meaning of these words too. Count 2. Count 2 alleges Mr. Cordova violated 41 CFR, Section 102 to 74.420, which prohibits photographing space occupied by a tenant agency without permission of the occupying agency. At A, B. It permits photographing, b. yielding entrances, lobbies, foyers, corridors, or auditoriums for news purposes. At C. I accept Mr. Cordova was filming for news purposes. So, was Mr. Cordova in space occupied by the SSA, or was he filming in a subsection, C, space, at the time he was arrested? I start with subsection, C. From the textual presentation in the regulation, subsection C is clearly intended to address a different physical space than subsections A and B describe. The spaces identified in subsection C appear to describe a series of like-kind words and should be interpreted as such. I agree with the following pertinent explanation. A justum generis refers to the principle that when a general term follows a specific one, the general term should be understood as a reference to subjects akin to the one with specific enumeration. Ali v. Federal Bureau of Prisons, 552 U.S. 214, 223, 128 SCT 831, 169 L.ed.2d 680, 2008, internal quotation marks and citation omitted. Relatedly, the doctrine of nocitur associis. Under all the interpretation rules and methods described above, I do not hesitate to ascribe to the first four of these a meaning that encompasses the first space into which Mr. Cordova entered on August 2, 2022, the glassed entry space where, logically, persons seeking to do business with the SSA would collect themselves, wipe their feet, brush off snow, or otherwise prepare to enter the SSA office. No SSA business would logically occur in this space, nor did any occur during the hours of filming on August 2, 2022. At first glance, the word auditorium has an apparently different...
Alright guys, so we're going to stop it there and we're going to go over some stuff here. Now, he's interpreting the four words to mean, pretty much the same thing, which they don't. He even applies, or he even has the hang on one second. Okay, so what he's saying here is that the first four words, the corridor, the foyer, I'm going to try to go back and get the other definitions here, because this is where I think he messes up at. So let's see. Trying to get it to go back. I don't know why it's not going back.
Encompasses the first.
Okay, so down here at the bottom, we'll see here. It says A foyer is an entrance hallway, and a lobby is a corridor or hall connected with a larger room or series of rooms and used as a passageway or waiting room. Okay, so obviously that entryway there is a foyer, right, where DMA was at for the majority of the time. That second set of doors, that was the lobby, right? Because there were chairs there for people to wait, waiting room, lobby, and then there were specific duty stations with half walls that they described up there for you. So that's a big point there. That again, like I said, I think they got wrong. Was he said that he wasn't in an entryway. Let's go ahead and see if we can go on here.
Where, logically, persons seeking to do business with the SSA would collect themselves, wipe their feet, brush off snow, or otherwise prepare to enter the SSA office. No SSA business would logically occur in this space, nor did any occur during the hours of filming on August 2nd, 2022. At first glance, the word auditorium has an apparently different meaning than the previous four words, but when applying a justum generis and nociter associes in the context of this regulation, it describes a space in which the public congregates, but would not be engaging in individual, personal transactions with the occupying agency, corporation, school, church, theater, or other organization. On the other hand, through that interior, second set of doors, the SSA conducted its primary business of assisting the public. During Mr. Cordova's filming, members of the public, including children, were indeed conducting business there. People were in chairs waiting for their turn. A customer check-in kiosk with a video screen was there, along with other indicia of a typical office setting. Mr. Cordova argues that 41 CFR Section 102 to 74.420 is unconstitutionally vague in employing the terms defined above. He contends that the area in which he was arrested could reasonably be included within the subsection C list. I disagree under the facts and circumstances of this case. Case 1:22 P07015 MEH Document 16 filed March 20th, 23 USDC Colorado page 6 of 8. 7. The 10th Circuit in the Baldwin case has noted in this regard, the Supreme Court has told us repeatedly that the relevant question in void for vagueness challenges is merely whether the defendant before us had fair notice from the language of the law that the particular conduct which he engaged in was punishable. 745F.3d at 1031 to 32, quoting Parker v. Levy, 417 U.S. 733, 755, 1974. It is clear based on the regulation, the signage in the SSA entryway, the instructions given by law enforcement, and Mr. Cordova's own understanding of the law that he had fair notice of the law and that his conduct in filming beyond the interior glass doors was punishable. The facts established Mr. Cordova knew the SSA and its law enforcement officials interpreted the law as prohibiting filming inside the second set of interior doors where the SSA was conducting business with its customers. He had fair notice of the language of the regulation, and that his conduct would be punishable under the government's interpretation of it. Granted, he has a philosophical disagreement with that interpretation, for which he was prepared to, and in fact, expected to, be arrested. Although I respect his right to challenge the law and test his constitutional rights to their outer limit, he is wrong in this instance. Under a different set of facts, where a person might enter from the outdoors directly into a federal office, the outcome could be different. Here, there was a distinct entryway from the outdoors, corresponding with a subsection C space, after which was a set of interior doors leading to a distinct and unmistakable office space, corresponding with subsections A and B. Without the SSA's permission to film in this office, which Mr. Cordova did not have, he violated the law. For these reasons, I find beyond a reasonable doubt that Mr. Cordova entered in and on federal property and unlawfully photographed space occupied by a federal agency, without permission, in violation of 41 CFR Section 102 to 74.420. Case 1:22.
Alright, so that's the end of it, but basically, you guys get the drift on the discrepancy here. A foyer is not a lobby. A lobby and the foyer are two different things. Even by his own definitions that he gave in the case, they're different. So, equating the foyer as a lobby just doesn't make any sense. So hopefully that'll get rectified on appeal. We'll see how that goes. We're pulling for DMA, of course. Also, there's other people in the community that have been getting charged with this. Good buddy of ours, this is a public service, was hit with 3 counts of each of these charges, and hopefully we'll get some resolve out of that. But there's definitely a lobby space in that interior, right? And that's different than the foyer. It's different from the entryway. It's different from a corridor. So we'll see how it goes, guys. Thanks for watching.